Worship, item number 9, Your Worship. I am permitted to withdraw. I will carry the affidavit also.
Serial number 9.
This is the affidavit.
Supplementary affidavit.
Supplementary I find it interrogatory, Your Worship. Copy has been served to the state.
What is the reason for withdrawal?
His grievance has already been
Filed.
Item 9.
Okay, WPC number 5109 of 97. Learned counsel for the parties are present. One interlocutory application has been filed before this court during the court proceedings, which is taken on record. Through this interlocutory application, the petitioner has prayed for withdrawal of the writ petition. The learned counsel for the petitioner submits that the petitioner does not have any surviving grievance. State,
By law.
any objection?
No, ma'am.
The learned counsel for the state has no objection to the prayer for withdrawal. Accordingly, this writ petition is dismissed as withdrawn. Interim order, if any, stands vacated.
Signed.
Prayer for continue.
This case item 2, WPA 3076 of 2014 along with item 3.
Given the revised notice.
Yes, I have seen that. But please, for the purposes of dictation of order, let's have the complete facts. A brief. There are two cases.
There-
One is 7175 and other is
3076.
3076. You say 3076 is dependent on the result of 7175.
Yes, because there is a finding that this is the 7175, it flows from that, because that 110 increment is also prior, in fact, prior to the bipartite settlement, and then the bipartite settlement comes. So therefore, in the second case also, they said tripartite will not hold good. You have to give 110, not 100 rupees increment.
Just a moment. Let us see how WPA number 3076 of 2015 is dependent upon the subsequent. (3076). We'll take up 3076 and tell us how is it dependent from the above and what was the reference.
The reference is at the annexure file, page 69. The award puts the reference.
69 is the reference. This is
So in fact, this is the previous one.
previous one.
This is the previous one. Annexure 6 is annexure 6. Sorry, I'm sorry, one annexure 1.
Annexure 1.
Annexure 1.
What was the reference?
The reference is salary of 4 categories. By notification numbers also and so dated 24/11/2011, the government of Jharkhand in exercise of its powers conferred under so and so section had referred dispute existing between the management of so and so. The terms of reference indicated in annexure salary of 4 categories of employees so and so has been fixed through an agreement dated 29 July 2008. This is the first bipartite mentioned in para 1, and the same has been made part of award passed on so and so in reference 1 of 2007 so and so. What will be the annual increment for all the 4 categories?
Now, the reference is not referring to the subsequent reference.
Yes, it is, but it is referring to the subsequent reference only in some paras.
Para 15.
Para 15.
When you read para 15?
Yes. Para 15, as observed earlier, the issue relating to validity of tripartite agreements and its effect on the employees of Nagarmal Modi Seva Sadan was addressed by this tribunal in the co-related reference case 1 of 2009, in which the management had raised the same stand as in the present reference, claiming that the tripartite settlement which was entered into between the management and its recognized union is binding upon the employees of the hospital. After considering the submissions made by the management and by the union representing the employees of the hospital, this tribunal, by its award dated 9/8/2012, had declared that the terms of purported tripartite settlement was not binding upon the employees of the hospital. In this view of the matter, the management cannot take refuge under the tripartite settlement against the workmen, so and so.
Read it further, admittedly.
Admittedly, with the same union which is presently pursuing the case of the employees of the hospital, the management had entered into a bipartite agreement on 29/7/2008, and on the prayer of both parties, the award was passed by this tribunal in the corresponding reference case number 1 of 2007, in which the terms of settlement was made part of the award. Admittedly, the management had issued an office circular assuring thereby to pay annual increment at the rate of rupees 110 to each of the employees with effect from 1/4/2008. So this is prior to that 29/7/2008. Admittedly, the bipartite agreement and the terms of settlement stipulated therein was to remain in force for a period of 4 years. The management, having acknowledged the role of the Jharkhand Pradesh Niji Aspatal Nursing Home Karamchari Sangh as the representative union of its employees, it cannot possibly retract by claiming that the aforesaid union has no local standi on the ground that it is so and so not a union recognized by the management. Any change in the terms of bipartite settlement could have been made only if the union which had entered into the bipartite settlement with the management was called upon for negotiations on behalf of the employees of the union. On the contrary, while entering into tripartite settlement, this union was not called upon, nor was it made aware of the proposed negotiations which the management had entered with the other union, which did not represent the majority of this finding is baseless. There is absolutely no evidence that the subsequent tripartite is not the majority. Even otherwise, the amount of financial benefits which was earlier assured to the employees and availed by the employees ever since the management's declaration made effective from 1/4/2008 cannot possibly be reduced. Furthermore, if under the tripartite settlement the rate of increment was fixed on the basis of 6 years period, whereas the period of operation of the settlement was only for 4 years, the union has rightly challenged the calculation and the rate of increment fixed thereby. Had the rate been fixed on the basis of 4 years calculation, then the rate of annual increment would have been much higher than what has been purportedly stipulated in the tripartite agreement. Considering the entire facts and circumstances, the claim of the union that the employees of hospital are entitled to get their annual increment at 110, which the management itself had earlier declared, appears to be reasonable and justified. The management's plea that it is the total emolument which has to be taken into consideration, not the basic pay, is misconceived and not relevant to the issue under consideration. In these circumstances, I record my finding.
So this is only on the rate of increment.
Only on the rate of increment. And that 110 is also not part of the bipartite set. It in fact even predates the bipartite. But this is the finding. Difference is also 10 rupees. So we had on the last hearing we had agreed that we may not even press this much because it won't make a lot of difference.
Basically it says that those people who have got, they will get it.
Yes.
So this you are not pressing,
This is not material,
not
not very material from our side.
whosoever has got it, they have got it. Now the time of that bipartite settlement has outlived.
Yes, it is outlived now. Much water has flown.
So
They have
whatever
used-
has been already granted, you don't want to disturb.
Yes.
That much should be sufficient for this step.
Yes.
And so far as this case is concerned, where is the agreement dated 29/7/2008?
Yes, that is it's at page 52. In fact, the award is page annexure 349 and page 52 because it is part of the award. It has been annexed with the award in reference 1 of 2007.
Samjhauta.
Annexure 3, page 49. Page 52, the bipartite settlement starts. 53. Yes, 53, 52 is the covering letter, 53 is the bipartite. It is only 3 pages. And the tripartite is at 56.
Where does it say it will be for a period of 4 years?
4 years. That is at page 55. Page 55, second last तक उपरोक्त लिखित समझौता संघ एवं प्रबंधक दोनों पक्षों के पदाधिकारियों के बीच आपसी एवं सहमति से हुआ है। समझौता दिनांक 1/7/2008 से 4 वर्ष के लिए दिनांक 30/6/2012 तक लागू है। बट इन द अवार्ड द ट्राइब्यूनल हैज सेड नहीं फ्रॉम द डेट ऑफ साइनिंग रहेगा।
ये साइन कब हुआ?
साइन हुआ है विद पेज 7 इंस्टेड ऑफ 17 सिग्नेचर होगा।
So far as this award is concerned, right, you are aggrieved by, so far as first finding is concerned, you are not aggrieved by
First
that.
finding we are not able.
You are not aggrieved. Let us see the issues and then we will just cull out whether. So
Yes.
first finding you are not aggrieved. It has been made effective from,
Date of signing.
that is 23/7.
Yes.
23/7/2008. Where is the finding? Is that para?
The finding is at page 100, para 22.
Para 20. Okay. And from which way the full inquiry and qualification will be entertained? What is it?
So that is whether a committee should be formed, how it has to be done. That is the only say-
Modality.
Modality. Because they had not specified the grades. The bipartites may be seen. The gradation of the pay is not there. Only 2300 to 2700.
What is the finding with regard to issue number 2?
Issue number 2 is regarding dearness allowance.
No, point number 2, from what way? 1 and then 2. How is issue number 2 has been
Page
answered?
101. Referring to the second full meaning and inquiry, it says Yes. The operative is at paragraph 24. 102.
24.
In the third para 24, third sub para, while the union has come up with a forced proposal, there should be a committee.
Okay.
Management has not offered any proposal. Management should constitute a committee of its own personnel to make an inquiry on the relevant aspects pertaining
Where are
to
you
its
reading? Page number?
page 102.
Bottom?
Bottom, last para, 24
While
is
the
divided
union
in-
has come up with a proposal.
Yes, it is in three parts, three sub-paras. While the union has come up with the aforesaid proposal, the management has not offered any proposal, neither has disapproved the proposals offered by the union. In my opinion, the proposal that management should constitute a committee of its own personnel to make an inquiry on the relevant aspects pertaining to experience and knowledge of the employee in order to assess whether he possesses due qualification.
So you are not agreed by this also?
This also.
Okay. So issue number 2 also you are not agreed. Okay. No grievance. This is also no grievance. This is at para number 24. Well, yes. Dearness allowance.
Yes.
Issue number 3.
This is the issue number 3. In this, the question
Third
was,
issue is 25, para 25.
yeah. So the dearness allowance issue is whether it is part of the basic or whether it has to be paid in addition to the basic as understood
Yes.
in the bipartite settlement.
Okay.
So the court has said it has to be separate.
Set. So it is in your favor. Technically. No.
Technically, we had opposed it. We are saying we have to see the total because if there is any ambiguity,
Here also no grievance technically. You have any grievance to this?
no major grievance. If otherwise now,
Now only that it is confined to that 4 years.
yes,
and
it
that
is confined to that.
and it will
4
not have a
years.
recurring effect.
It will not
otherwise.
have any effect.
That much should be sufficient.
That is sufficient. And now, because minimum wages says you have to give separately, they are notifying VDA separately, and
Okay.
but the general law is in air
So we
freight
will, you
case.
see, this we'll say that this particular adjudication is primarily confined to your 4 years, and so far as 4 years is concerned, as per the settlement, it has been interpreted to be inclusive, right? And what about the last one?
Then is the what is para 27 categorization.
Yes.
Now in this, while doing categorization,
They have referred to minimum
they
wages,
have
and you
referred
say
to
that
minimum wages.
authority under the minimum wages have exclusive rules.
We have
Merely
this-
by experience, it cannot be.
Yes, merely by experience, and moreover for nurse, there is a finding that they are in skilled category, which we are saying that nurses have been placed. They have also mentioned nurses have been placed in two categories, both upper and lower. The reason for not prescribing even under the act any particular grade, whether they fall under semi-skilled or skilled, is because nursing as a profession itself is very fluid. An A&M nurse could have a basic diploma. A trained nurse could have a degree in nursing and more
Different
experience and expertise.
qualifications are there for nursing.
Different qualifications are there, and therefore to say that by our placing them in two categories it was ambiguous or absurd is also not correct. So nurse, we have said that it cannot be in one straitjacket formula in skilled category, which has been done by the tribunal. Even in another minimum wage case, which is contemporaneous and which we have annexed the order, in that the labor court has said it is semi-skilled. So we have conflicting orders from the
So
tribunal
whatever impact you have given to your bipartite settlement for 4 years,
for 4 years.
it's so even this adjudication will be confined only to that 4 years.
Here we are in a little bit of dilemma whether because once they say skilled, whether we can pull them down to semi-skilled.
No, if you have given any status to anybody, why do you need to pull them down?
No,
They will attain the age of superannuation with passage of time, isn't it?
Yes, but because this was not implemented and challenged, so I have been instructed that they are still, most of them are in semi-skilled. Only the trained ones have been given skilled category. as per tripartite. Those who have a degree, but there are many on-the-job trainee nurses also who are pursuing A&M
So
course.
merely by virtue of experience, they cannot be given.
There cannot be any. And for that we have given a judgment also, which is the Punjab judgment. It is clearly held in Hindustan Sanitary Ware that minimum wage notification was struck down. Jharkhand government also came with a similar provision. Jharkhand government deleted it. That judgment is also there, by which Jharkhand government, in fact, many employers had to deposit the money in court when they had challenged the notification. But after the decision in Hindustan Sanitary Ware from by Supreme Court, the Jharkhand government itself decided that this clause that by completing 5 years you will shift to the next higher category was deleted,
And while deciding
the money
the
was
case,
reimbursed.
while deciding the case, they have referred to minimum wages only.
They have referred to minimum.
So that particular provision now does not survive anymore.
That provision itself is struck down, deleted also,
Where
omitted.
is that? Where is that judgment?
That judgment is there in the first compilation that we have given.
Yes. Hindustan Sanitary Ware.
Hindustan Sanitary.
Where is that finding?
Hindustan Sanitary. 14 to 8. Flag A.
Place it, please.
14.1 is the notification dated 21/10/2015 postulates that unskilled employees having 5 years experience would be deemed categorized as semi-skilled A, that after 3 years of experience in semi-skilled A, the employees would be deemed categorization as semi-skilled B, that after 3 years of experience in skilled A, the employees would be deemed categorized as skilled B. Such categorization or classification by deeming workmen in one category to belong to another category is in direct contravention of the contract between the employer and that is the employee and is beyond the jurisdiction of the government. Inclusion of so and so, these are the other issues. And then the finding at paragraph 18. Our conclusion in respect of some parts of the notification will not affect the notifications as such. The part of the notification other than that which are dealt with by this judgment shall continue to be in force. We make it clear that the employer shall not be entitled to recover any amounts paid under the notifications to the workmen on the ground that they have succeeded in this case, as the findings recorded in this judgment pertain to the jurisdiction of the government under the Act. The workmen are not precluded from resorting to redressal of other remedies regarding their grievances. The upshot of the above discussion is the prohibition of segregation of wages into components in the form of allowances in the notification is impermissible. The security inspector secure so and so cannot be included in the notification. Trainees who are employees without payment of any reward cannot be covered in the by the notification. Categorization of unskilled employees as semi-skilled and semi-skilled as skilled on the basis of their experiences ultramarine.
That's right. But so far as the bipartite settlement is concerned, that talks about such kind of scheme, right?
Yes.
Therefore, we will just observe that if you have given benefit to anybody, that
It should
will
not be
taken.
recovered.
There is no question of any recovery, nor it can be taken away.
Yes.
The bipartite settlement does not exist anymore,
Okay.
right? It has outlived, and now there is a new law. So you will be governed by the existing law.
Existing.
Whatever it is.
Even
That should be sufficient.
yes, tripartite may not be there. I'll be
Whatever
governed by
be the law, we don't bother
the
about
law
it.
is that there is no such provision. In fact, the Jharkhand government also deleted that Jharkhand government judgment I had also given.
Where is that?
paragraph 8, Jharkhand government deleted it, relying on
That's-
Hindustan
That's
Sanitary.
para 8.
Para 8. It has been submitted that based on the judgment in the case of Hindustan Sanitary Ware and Industries, the state of Jharkhand has deleted column 5, the remarks column of the notification which related to service weightage, and the said deletion was made by notifications number so and so. Learned Council has, in the aforesaid scenario, confined his submissions to refund of the amount which was deposited by the petitioners in an interest-bearing account since the major grievance of the petitioner. So this is relating to remand, but this only to the purpose to show that even Jharkhand government deleted the similar provision based on the decision in
14.
Hindustan Senate. And in this case, in fact, they even got refund, but we are not even pressing for any refund. He's saying that the law as it stands today, nobody can be said to be in a higher category or in a semi-skilled category only by experience
That's
doing the same work. It is dependent on the job profile and not experience alone. Nature of job.
And where is the finding with regard to tripartite agreement, which you say that has been wrongly
There
left
is no clear finding. There is a recording that
that will have no bearing.
that it will have no bearing. They said it is illegal, it is arbitrary, but on careful reading, I have not found that the tribunal said that it is set aside. The tribunal has said it will have no bearing. This will prevail because it was not cancelled.
Anything you have to say, Mr. Mehta? That should be
1,
sufficient.
2, 3. There's nothing.
There is nothing. For 3, we will say it will be confined to that 4 years, and whosoever has been granted, their benefits will not be nullified. And now they are governed by the new law. Because
In
it
any
has
case,
been
they must
declared
have been governed. But since the matter is here,
Yes.
it needs to be disposed of like the reference.
Yes.
It was disposed of on all three,
Yes.
1, 2, 3 and 4 issues.
Yes.
So we are
It was
concerned with
decided on the basis of whatever law was prevalent regarding minimum wages at that point of time, but that has been held to be ultra vires. Ultra vires goes to the root of the matter ultimately. But still, whatever benefit was extended to the employees was saved by the Supreme Court also.
And in the second case, we
Second
want-
case, they don't want to press it. Whatever benefit, they don't want to press it on instructions. Simple. WPL number 7175 of 2012 with WPL number 3076 of 2014. Heard the learned counsel for the petitioner in both the cases and learned amicus, Mr. A.K. Mehta advocate.
I may be excused.
Hi. Thank you for the assistance, whatever you have rendered, and please raise your bill. Don't forget to raise your bill.
That is our discussion.
No, it is not your discretion. It's the moment amicus raises the bill, even we feel that yes, it is not a matter of money. The money is being provided by the government. So why do you can give it to anybody you want to distribute amongst your junior. The learned counsel for the petitioner submits that these two cases have been tagged in view of the fact that both the matters are relatable to the settlement dated 29/7/2008. The Learned Council has further submitted that earlier in point of time, a reference was made which was numbered as reference case number what is the details of the reference case?
1 of 2007, page 49. The first
You have not mentioned it in your writ petition,
petition.
which was numbered as reference case number 1 of 2007. The reference was in connection with a certain demand raised by the nurses,
The union.
the
Jharkhand
union
Pradesh.
on behalf of the nurses,
On behalf of all the employees.
on behalf by the union on behalf of the employees. The union was Jharkhand Pradesh Niji Aspatal and Nursing Home Karamchari Sangh. The terms of reference was as follows, page 49 में है. Whether the 13-point demand letter dated 26/11/2006 raised by Jharkhand Pradesh Niji Aspatal and Nursing Home Karamchari Sangh to the management of Nagarmal Modi Seva Sadan Upper Bazaar Ranchi is justified? Question mark. If not, then what relief the related workmen are entitled to? He submits that during the pendency of the said case, a settlement was entered into dated 1/7/2008 for a period of 4 years, that is till 30/6/2012, and the reference was disposed of by order dated 31st of July 2008 in terms of the settlement. The settlement has also been placed on record along with the award dated 31st of July 2008. He submits that vide another notification dated 24/3/2009 reference was made primarily relating to certain clarifications arising out of the bipartite settlement dated 29/7/2008. The terms of reference are as follows. Page 82 में terms of reference है paragraph number 2 में. The Learned Council further submits that so far as point number 1 of the said reference was numbered as reference case number 1 of 2009, which has been decided by impugned award dated 9th of August 2012, which is subject matter of challenge in WPL number 7175 of 2012. With respect to point number 1 of the terms of reference, the Learned Council submits that there was a confusion as to what would be the effective date from which the benefit of the agreement dated 29/7/2008 would be payable, whether from the date of appointment or from the date of agreement. And the same has been answered by paragraph 22 the learned court has opined that the bipartite settlement would be effective from 29/7/2008. He submits that he has he also submits that since the bipartite settlement was for a period of 4 years, it would remain effective from 29/7/2008 till 28/7/2012. He submits that he has no grievance so far as the said finding is concerned. With respect to point number 2, as per the terms of reference, the Learned Council has submitted that the finding of the Learned Tribunal is at paragraph number 24, wherein the Learned Tribunal opined that the proposal that the management should constitute a committee of its own personnel to make an inquiry on the relevant aspect pertaining to experience and knowledge of the employee in order to assess whether he possesses the due qualification for undertaking the assignment of higher category was reasonable, and therefore the proposal was approved. As the manner in which the inquiry relating to qualifications of the employee for his promotion to the higher category is to be adopted. He submits that so far as the modality is concerned, the petitioner does not have any grievance, and the finding in connection with point number 2 in the terms of reference also need not be gone into. With respect to point number 3, the Learned Council submits that the same is dealing with claim of dearness allowance, and as to whether the dearness allowance is to be included in the pay or not, the same has been answered in paragraph number 25. The Learned Council submits that the tribunal has answered it by saying that the employee would be entitled to salary in accordance with the scale fixed for his grade, and in addition thereto, the dearness allowance would be payable at the rates fixed variable in accordance with the government notifications. The Learned Council submits that since the matter was arising out of bilateral agreement dated 29/7/2008, therefore it would be suffice if it is observed that the finding recorded in paragraph 25 should be confined to the implementation of the bilateral agreement only. That's it. He submits that bilateral agreement is followed by a tripartite agreement, and therefore the employees may be governed by the tripartite agreement or subsequent agreement or as per the provision of law. The Learned Council has submitted that the bilateral agreement has outlived the period for which it was made. With respect to the point number 4, the Learned Council has submitted that the Learned Court has referred to the provisions of Minimum Wages Act 1948 and the notifications issued thereunder, and has approved that the term and has approved that the classification from unskilled, semi-skilled, and skilled and highly skilled would be acquired through experience.
There's an additional submission contrary to the judgment also, and even in the bipartite settlement it is only for 4 years. So therefore saying that and the minimum threshold is 5 years. So it is again beyond just
The
as our
Learned
tripartite
Council
settlement
has
is been
also
referred.
submitted that the bipartite settlement was only for a period of 4 years, and the minimum period to shift to the skilled category from semi-skilled category was 5 years experience. Would not have any meaning. The Learned Council has further submitted that merely by virtue of experience, the category cannot change. He has also submitted that categorization of workforce is essentially to be performed by the authorities under the Minimum Wages Act. And the finding of the Learned Court and has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2019 bracket close 15 SCC 774 paragraph 14 to 17 to submit that ultimately in paragraph 19 it has been held 19.4 it has been held that categorization of unskilled employees as semi-skilled and semi-skilled as skilled on the basis of their experience is otherwise. He submits that the said judgment was passed with specific reference to Minimum Wages Act 1948. The Learned Council has further submitted that even the The state judgment passed in the case of Hindustan Sanitary Ware, reported in bracket 2019 bracket close 15 SCC 774, has been followed, and the state of Jharkhand has deleted column number 5, that is remarks column of notification, which related to service weightage, and such notification was issued by notification dated 11/5/2023. He has further submitted that the prospective part has been rejected, para 9.
Para 9 is in operation cannot be waived on account of prospective nature. Yes. If there is para 12, straight away it says that the primary grievance is now redressed because they have suo moto deleted the provision itself. So on merits, the adjudication, there was no requirement of quashing.
The Learned Council has also submitted that ultimately, on account of the deletion made by the state government, a batch of writ petitions were disposed of by this court by judgment reported in 2023 SCC online Jharkhand 2652, and the amount deposited by the writ petitioners who were the employers in the said case was directed to be refunded to them.
They had not paid to the employees, they had separately demanded
Yes.
because they had challenged the notification.
The amount was deposited in the bank account and were not directed to be paid to the employees and was directed to be refunded. The Learned Council submits that as of now, the concept of promotion from one grade to another on the basis of experience no longer survives, and therefore the impugned award be confined only to the period of 4 years and may not have any bearing in subsequent periods or any action taken by the employer/employees by virtue of subsequent settlement or as per applicable law. Right? So far as the writ petition number WPL 3076 of 2014 is concerned, the Learned Council submits that certain benefit having been granted by the award he has been instructed, which amounts to rupees 10 per person, right? Increment of
Difference,
rupees 10
yes.
only.
Difference in the increment.
Difference in the increment of rupees 10 only. So on instructions, he does not want to press this. After here, the Learned Council and the Learned Amicus, on behalf of the respondents in both the cases, has submitted that the case arises out of bipartite settlement which had a life for only 4 years. He submits that it would be suffice to observe that any person who has been granted the benefit arising out of bipartite settlement may not be disturbed. And so far as subsequent periods are concerned, the parties may be governed by the applicable law or tripartite settlement, applicable law or the settlements. After hearing the learned counsel for the parties, learned counsel for the petitioner and the learned amicus, this court finds that in reference case number 1 of 2009, altogether 4 issues were framed, and as of now, the petitioner is aggrieved by issue number 3 and 4 only. Primarily, the concern of the petitioner is that the agreement, that is a bipartite settlement dated 29/7, the bipartite settlement by virtue of which the reference case number 1 of 2007 has been disposed of, be confined only to 4 years, and the impugned award may not have any bearing on subsequent settlement or for subsequent period, and parties should be governed by the law as may be applicable. This court finds that so far as the point regarding, this court finds that the terms of reference was essentially in connection with the bipartite settlement, and some clarification was required. And so far as the findings with regard to Dearness Alliance is concerned, with regard to issue number 3, it would be sufficient to observe that that finding is only in connection with the settlement which remained effective for only 4 years and will have no bearing for any subsequent period after the settlement outlived its life. The settlement remained effective for a period from
Now since the
29/7/2008 to 28/6/2004. So far as the issue number 4 is concerned, the learned tribunal has essentially referred to the provisions of Minimum Wages Act, and has ultimately held that the employees working as sweeper, dye, ward boy, and guard fall in the category of unskilled worker. Nurse, sister in charge, and assistant matron are to be placed in skilled category. The said finding is essentially based on experience. The findings are at paragraph 27, which are quoted as under. In the judgment passed by Honorable Supreme Court, reported in bracket 2019 bracket close 15 SCC 774, it has been clearly held in paragraph 18 that the part of the notifications paragraph 18 in paragraph 14.1 that the notification dated 21/10/2015, which postulates that unskilled employees having 5 years experience would be deemed categorized as semi-skilled. A, that after 3 years of experience in semi-skilled A, the employee would be deemed categorized as semi-skilled B, semicolon. After 3 years of experience in semi-skilled A, the employees would be deemed categorized as skilled B. Such categorization or classification by deeming workmen in one category to belong to another category has been held to be in direct contravention of the contract between the employer and the employee and beyond the jurisdiction of the government. The Honorable Court was dealing with categorization under the Minimum Wages Act 1948. And in that background, the Honorable Court has held in paragraph 19.4 that categorization of unskilled employees as semi-skilled and semi-skilled as skilled on the basis of their experiences are otherwise. In the present case, the matter essentially deals with the settlement dated 29/7/2008, which was effective for a period of 4 years. It would be sufficient to observe that if one or the other employee has been given the benefit of the settlement dated 29/7/2008, such benefit cannot be withdrawn as the benefit is in terms of the settlement. However, whether one or the other employees, if not granted such benefit so far, will certainly have to satisfy the scrutiny committee who is required to consider in terms of the finding recorded with respect to issue number 2. It is further observed that the settlement was only for a period of 4 years and will have no bearing on any subsequent period or subsequent settlement, and concerned employees would be governed by the subsequent settlement slash arrangement slash arrangement as may be applicable upon them and would be governed by the applicable laws from time to time. The writ petition being WPL number 7175 of 2012 is disposed of in their aforesaid terms. So far as the other writ petition is concerned, the same is dismissed as not passed. इसके बारे में लिखे that arising out of the award in WPL number 7175 of 2012 to the best of your knowledge no execution cases pending. You have no idea.
We don't know.
Not required. You have no idea.
Item 4, WPL 3188 of 2014.
Before judgment. Item 4.
5.
अच्छा. Okay. You are there?
Yes. Actually, what is the input? Input award. In 17, terms of reference is whether the action of the management of Surandi area office of Messrs. BCCL in dismissing Sri Durgashan Mahato from service of company with effect from T. Shigara 94 is justified. If not, what relief the government is entitled? The fact is that if Durgashan Mahato is served with Vishu Mahato, Vishu
Durgacharan
Mahato
Mehta is?
had sold
No, I don't get it.
and sold some land to BCCL, and in lieu of that land, this Durgacharan Mahato got service. Subsequently,
Durgacharan Mehta? I don't get it. You just place it from the
Durgacharan
award, please. What was your case? You read it from the award. The case of the workman. Read the case of the workman from the award. Para number 2.
yes, I am reading the award notes. From paragraph 2, from page 2,
Yes.
the case of Durgacharan Mahato, as stated in the registered is that he was appointed as a minor loader in Bhavra, North Colliery, under Bhavra area of Messrs. BCCL in the year 1983. So very well known. As per the letter number so and so of Team Non 1983. Thereafter, he was transferred to Sudamda area as a data entry operator, as a permanent employee of the company. He had got his employment after full legal formalities under the land loser scheme of the company, subsequent upon the acquisition of Moja Gaur Khuti, Moja 113, Khata number 20, lot number so and so, 1.98 acres, appears Yorapur district Dhanbad, by company from his vendor Vishu Mahato. Vishu Mahato is father of the present petitioner. Vishu Mahato, as per registered deed of sale deed number so and so of 1981. as it was purchased land of said vendor by virtue of 3 registered deeds, number so and so, 1967, 95, 1967, 1973, respectively, as mutated, a rent regular being paid, but suddenly management illegally issued the workman a false charge sheet as per letter number so and so of 1992 for the misconduct on the ground the land purchased by BCCL did not belong to aforesaid vendor Bishu Mahato, the father of the present petitioner. Bishu Mahato. Rather, it is a government of Bihar Khas land. The initiation of the proceeding by the management after a long period of 11 years against the workmen as illegal. At the time of purchasing of the land, the BCCL is having on legal department scrutinized everything. Thereafter they purchase the land. Now after 11 years, the domestic inquiry was not conducted fairly, properly, according to the rules of natural justice, as he was rather than full opportunity, as he was neither given full opportunity, it or not furnished with documents of land of Bihar Khas land, and the report of circle officer concerned and demanded by him. Likewise, the management failed to prove the charges level against workman. Yet workman was illegally dismissed as per letter number so and so in 1994. Since there was no employer-employee relationship between the management and the workman prior to his appointment, the workman had not committed any misconduct under clause so and so certified standing order as alleged by the management. The action of the management dismissing the workman from service on T-94 is illegal and justified. At last, the failure due to adamant attitude of the management in conciliation proceeding in the industrial dispute raised by the union resulted in the press application. Now, what management said, next paragraph.
Yes.
Whereas the case of the management, as pleaded in its written statement, come rejoinder with categorical denials is that the present reference is unmaintainable in law and facts. In the year 1980-81, the workman fraudulently sought his employment in Bharat Coking Coal Limited, India, an limited company, by claiming himself as dependent.
The property
of
was
Vishnu
transferred to them by virtue of a registered deed in the year 1981,
Yes, yes.
which your father had purchased way back in the year 1973 through a registered deed.
Yes.
Subsequently, what was the material to find out that the land actually belonged to the government?
The circle's officer's report was called for
Yes,
by
respondent.
in the domestic
Just a
inquiry.
moment. The land they had purchased in the year 1973 by registered deed, right? You also purchased the land from his father in the year 1981 by a registered deed. Okay. Subsequently, what was the material to find out that the land belongs to the government? You must have given them compensation also.
Yes, Your Ladyship.
Must have.
We purchased the land. We paid the compensation.
That's right. And
And
you paid.
subsequently-
You gave the employment.
Correct.
Yes.
Subsequently, it had come to light from circle officer's report that the land is not in the record of rights. The land is not named against a person. It's not recorded. It is a government land.
So
And-
who will the government will go and get its title declared? What's the big deal about it?
Thereafter,
Is there any declaration of title? Now there is a title dispute.
And that deed was not cancelled ever.
Now there is a title dispute between government and these people, and now qua CCL, you are CCL, BCCL.
BCCA.
BCCL. So if the government record says that some entry has been made somewhere, where were you when you were purchasing the property?
The officer who was supposed to look into these matters, he is also charge sheeted in
We
this.
don't bother about it. His entire claim is backed by title deeds, registered sale deeds.
No, that is not.
Yes, it is.
For that part, allow me, your leadership, to.
Who has declared the title? The government has declared its title itself.
No. The circle officer's report says that it is the land is recorded in the name of the government. Now we have set up an inquiry and we asked them to produce the registered deeds or from where they had purchased their lands previously. Now,
Previously means beyond 1973.
right
Which
before,
deed?
they claimed that their father claimed that he had purchased the lands from some other person and then he had sold it to BCCI. So, in order to verify their title, we had asked them to produce from where they are deriving their title. Now, in this process, page number 171 of the LCR, that is part of the inquiry report, that will be seen.
That
What are the
inquiry
findings?
was never given to us, in spite of the serious demand.
In respect of Sri Kedar Mahato and Durga Charan Mahato, page number 171.
There are two brothers of Vishnu, sons of Vishnu.
Yes.
Sri H.N. Sarkar has produced the documents as Exhibit 26A, in which Sri Bisu Mahato had alienated this land to provide employment to Sri Durga Charan Mahato, Bihari Mahato, Kedar Mahato, Satyendra Prasad, Kapil Prasad, Dulal Prasad, Ganga Prasad, and accordingly Sri Durga Charan Mahato, son of Bisu Mahato, and Kedar Mahato, son of Bisu Mahato, were provided employment under land acquisition scheme. Sri H.N. Sarkar confirmed in his statement that Sri Bisu Mahato had alienated the following land for which employment was provided. Sale deed number so and so, these are the details. Sri H.N. Sarkar further submitted Exhibit 27, in which it has clearly been mentioned by the Circle Officer Jharia that there is no entry of any tenant in the records. Sri Kedar Mahato and Durga Charan Mahato in their statement have indicated that their father Sri Bishu Mahato has purchased 66 decimal of land from plot number 265 wide sale deed number 3795 in the year 1967 from Sri Bhaktu Mahato and 66 decimals of land wide sale deed number 12899 of 1961 from Sri Jailal Mahato and Jagtu Mahato and 66 decimal of land under sale deed number 20388 of 1974 from Sri Jailal Mahato and Jagtu Mahato. But both have failed to submit any deed in support of this statement. They have further stated that they have purchased the plot number 190 of area 76 decimal, plot number 264 of area 0.54 acre, plot number 290 of area 2.78 acres and plot number 250 of area 1.04 acre. But as per Circle Officer Jharia's report, these lands are not settled with any tenants and remain as GM land. Sri Kedar Mahato and Sri Durga Charan Mahato have not submitted any documentary evidence in support of their statement. While Sri H.M. Sarkar has submitted the letter from CU Jharia, which clearly indicates that these lands are not settled, clearly prove that Sri Kedar Mahato and Durga Charan Mahato were provided employment against the land which did not belong to Sri Vishu Mahato. Hence, the charges leveled against them that they entered into employment by fraudulent means stand proof beyond any doubt. The right.
That deed is still there using. They have not taken any step to cancel that sale deed. They are enjoying that sale deed.
This property is in your possession.
Yes.
They have given compensation to whom?
The claimant has the
Have you got any fresh deed from the government? No. See, there is a registered sale deed by which the transfer is taking place. The registry office also does not object to it. Right? You also verify the records in whatever manner you could have. Right? And then on the basis of that you give them employment. And suddenly on the basis of a report of the circle officer, you say that the property does not belong to them. And they were not able to produce the sale deeds. Right? These sale deeds are registered sale deeds.
These,
Yes.
Right.
Isn't it?
yes,
These
yes.
sale deeds are registered sale deed. So what's the
They
big
have
deal about it?
stated that deed numbers principle is there, but they have not brought on record these deeds.
Can't be like this.
Impugned judgment.
You
Award
must
is
have done your.
some-
What is the? Where is the finding of the impugned judgment? Let us see.
At paragraph 9,
Yes.
after hearing the argument of workman Durga Charan Mathur and Mr. D.K. Verma, before this there is a recording that findings with reasons, page number 3. After due hearing and considering at the preliminary point about the fairness of the domestic inquiry, the tribunal, as per its order number 31, dated 15/3/2011, has held the inquiry as quite fair, proper, and as per the principle of natural justice. In result, the case directly came up for hearing the final arguments on merit. And after that, paragraph 9. After hearing the argument of workman Durga Charan Mathur and Mr. D.K. Verma, learned counsel for the OP management, and I have minutely perused all the materials in the case record, I find the facts as under. There is no dispute in the fact that workman Durga Charan Mathur, just as his brother Kedar Mathur with 5 other alleged relatives of Bholanath, Kapil Prasad, Bihari Prasad, and Satyendra Prasad as nephews and son-in-law of his father Sibu, got employment in the colliery concerned under the land looser scheme by virtue of the sale of the total 5.85 lands in issue by aforesaid Sibu Mathur as his own lands to the BCCL. At the investigation into it by the vigilance authority concerned, as per the reports of the circle officer Jharia, out of the total 5.85 acres of land sold by Bisu to the company, 4.58 acre comes under Gairabad. Khata number 20 is Gairabad Malik, Khas, not recorded in any tenant's name, but area 70 decimal land under Khata 12, in respect of which revenue receipt stands recorded in the name of Bhagatu Mathur and others, from which Bisu alleged to have purchased. So the lands under the Khata area 5.15 did not belong to Bisu, the father of workman Durga Charan Mathur. So his employment at the imitation
So only the
initially-
part of the land did not belong to him.
major
Not the
chunk of it. 4.58 acre comes in Gairabad.
Area 5.15 did not belong.
Area 5.15 did not belong to BC.
There is no declaration of title. You have taken the property by virtue of a registered sale deed. So that cannot be a ground. When you say it is fraudulent, go and seek a declaration that title. You see, there are many entries in revenue records. That by itself will not be a conclusive proof of any title. Even the mutation will not be a conclusive proof. Whenever you buy a property, you have to done your you have to do your homework, isn't it? The things which you are pointing at now, why was it not seen at the relevant point of time with the and not the entire chunk, only a portion of it, what maybe the major chunk has been said to be not belonging. 5.85 acres was transferred. Out of that, you say 5.15 acres did not belong to him. Then why have you cancelled your appointment?
But on the basis of that transfer only, this
You
workman
see,
along
at the
with
time
others,
when you purchase the property, you are supposed to do your all the homework. and then get the property. The sale deed is still existing.
Still exists.
You have not got the sale deed cancelled. Nobody has got the sale deed cancelled. You are enjoying the property by virtue of that very sale deed, isn't it? You don't want to get it cancelled. Do you want to get it cancelled? No. It is in your favor. You will not get it cancelled. State is not bothered about it because the land has already been acquired. So you are enjoying that property by virtue of that particular sale deed. And on the top of it, the entire property has not been held to be not belonging to Vishnu Metro.
That is correct.
So,
Your Lordship, allow me to file a supplementary.
what
bringing- To verify the present status of the
we have the
You
entire
have not
records
filed counter
here.
affidavit. You have not filed counter
No,
affidavit.
there is no question of counter affidavit. We have the entire records. We are in WPL jurisdiction. There is no question of any supplementary affidavit. Do you think that your company will go and get their sale deed cancelled
But
themselves?
before the tribunal, the inquiry proceedings, the disciplinary proceedings were held to be fair and proper. So that opportunity
Very well,
was
it
not
has
given.
been held to be fair and proper. Then,
So that opportunity of bringing on record any paper in support of the management's case was not given.
now on the face of the finding that as per the inquiry and everything, only a portion of it did not belong to the father, but some portion did belong to him,
Some portion did.
then you cannot cancel it. You cannot cancel that payment. Why have you only picked him up? There are so many
No.
persons who gave
Along
him.
with him, all the persons who had been given employment, they have all been charge sheeted. And in the
So
inquiry
consequently,
report,
so consequently, a portion of the land has been taken, right? And then all of them have been charge sheeted,
well,
and they have been dismissed.
it's- the allegation is that they have committed fraud with the company.
You have not got the title declared so far. There is no declaration of title.
But during the inquiry proceedings also, they also did not substantiate their title.
They have substantiated the title by
They
virtue of
only
the fact
referred
that
to registered deed numbers, but they never brought it on record. And at least they should have brought the record of rights somewhere where their ancestors' name is written. Because the circle officer is saying that there is no tenant's name written on the record of rights.
And the circle officer's report is with you. You have never given to me. It's quite on demand.
And it is not as if this dismissal has been done within a day or two or within a week. This continued for a pretty long time. And we have also charge sheeted the persons from
At the
BCCL
conclusion of the
who were
award,
involved in this, moving the note sheet and
at the
providing employment to
conclusion of the award is also given the terms of reference.
you have cancelled the appointment of only two persons, Kedar Mehto and Durga Charan Mehto. What about the rest? There were many persons who were given appointment against this land, but you have cancelled the appointment only against two persons.
it should be there because this writ is dealing only with the writ petitioner. The inquiry report says that the charges have been found to be correct.
Therefore, it is clearly proved that Shri Kedarnath Mehto and Durga Charan Mehto were provided employment against the land which did not belong to Vishnu Mehto.
And separate findings are against each of the charge sheeted employees. This inquiry report, this runs from page number 155 to page number 175, that is the last page.
So far as this person is concerned,
Specific finding has been given.
no,
at-
with respect to Vishnu Mehto, this is the only proceeding. There are others also.
Vishu Mahto is the father.
Yes. With respect to property of Vishnu Mehto, this is the only one.
And there is also a finding that against the land sold by Vishu Mahto, certificates were provided that they are related to Vishu Mahto, which have been found to be false.
What has been found to be false?
Nomination, they were nominated by the village Mukhya, certified that he is the son and he should be given
They are not
employment.
the sons.
They were not the sons. Not
These
related.
two persons were not the
They,
sons.
they were.
They were the sons, no?
He, at least the petitioner,
At least there is no dispute regarding
There's no dispute.
parentage.
there's no dispute.
We have a permitted to sit, Willard.
Ah, yes, please have it.
And even in their written statement, they have not claimed that the 5.85 acres of land belong to them, belong to his father. Neither it is the case right now before your ladyship.
In writ petition, they are not supposed to make out any case.
Right.
What was their show cause?
Written argument
What
on
was
the-
their show cause before the management? It is under 11A. What was their show cause before the management? Or was it an ex parte?
No, they participated. They
So,
fully
where is their
participated.
show cause? Exhibit?
There's one reply to the charge sheet that he had filed.
Yes,
That is at page number 91.
90. Durga Charan. Kindly read that. You have a copy?
He has merely asked for the documents. Here he has asked for the specific details of the lands against which he has been provided employment. And he is a beneficiary of land acquisition. And the second
So,
document he has
just a
sought.
moment. So, how much of land belongs to Vishu Mehto as per the impugned award? Let us deduct it and see how much is that. 5.85 minus 5.1, right?
0.70 decimals.
So, according to you, is there any particular plot number or area, any area against which this person was given employment? Because he was asking you that.
The details have been supplied at page number 171 of the inquiry report. Sale lead number and date 773 dated 3181. Plot numbers 268 0.06 acres. 774 dated 3181. 268 plot number 268 0.10 acres. 265 1.98 acres. 190 0.76
Out
acres.
of these sale deeds, which sale deed is forged, according to you? Because there has to be a sale deed to the extent of 0.70 decimal. At least sale deed is valid to some extent.
It should be.
That is why he was asking that against which area he has been granted the appointment.
There's no specific area
There is
mentioned
no
against
specific area. So the fact remains that the father was holding title with respect to some portion of the land which was sold to you, and they have been granted appointment. So
But the chunk of land that was given to the management earlier,
there were
against
numerous
which
persons who were given appointment.
numerous persons were given
Yes.
employment against the same chunk of land.
Yes.
And the
But you have not proceeded against numerous persons.
all of them have been charge sheeted and we have proceeded against them. The inquiry report, all of them have been
This
proceeded
inquiry
against.
report.
This inquiry
In this
report.
inquiry
In this
report
inquiry report itself.
Show us. Show us. Hey.
Page number 155, inquiry report submitted by Shri Bhagwan Prasad, Deputy CPM, Inquiry Officer, Bhaura area into charge sheets number so and so dated 25/9/12/10/92 issued to Shri H.N. Singh, Office Superintendent, Zamindari Section, Bhaura area, Office, charge sheet number so and so dated 12/10/92 issued to Shri A.K. Yadav, Senior Stenographer, Bhaura area.
Is it in connection with the same property? No. I was trying to find out. It is not in connection with the same property.
The details of the lands that have been sold are given at page number 5 of the inquiry
You see,
report.
the details of the land that was sold, right, so far as the father of the petitioner is concerned, that we have seen.
Bishuma.
Arising out of the property which was sold by Vishu Mehto, who all are the other persons against whom you have proceeded? Because there must be some other persons also who were granted employment.
There is a detail of all the persons who have applied.
Arising out of the same property.
Same property. Page
This
number 5.
1981 property.
Same property. This is in the inquiry report itself. Through Bisu Mahato, Durga Charan Mahato, appointment on the basis of relationship, son of Bishu Mahato, Sri Bihari, through Bisu Mahato, Sri Kedar Mahato, son of Bishu Mahato, Sri Satyendra Prasad, through Du Bishu Mahato, Sri Kapil Prasad, through Bishu Mahato, Sri Ganga Prasad, through Bishu Mahato, Sri Bhole.
They were found to be not his sons.
That is in the inquiry report. They have claimed to be nephew, son, son-in-law, nephew.
And what is the inquiry? What is the ground of cancellation of their appointment?
The ground in the certified standing orders, they have been charged under 26.1.11 of the certified standing orders.
You are not getting what I am saying. Arising out of the same chunk of land, there are numerous other persons who were granted appointment.
Correct.
Right? Enumerate them. Who are the persons who were granted appointment by virtue of this sale deeds of the year 1981 executed by Bishu?
Specific portions of
Yes.
land has not been given against their names. It is a big chunk of land against which these persons were nominated for employment and they were provided employment. 3 persons have sold land to BCCL, Bishu Mahato, Sibu Mahato and Arjun Mahato.
We are not concerned with Sibu Mehto and Arjun Mehto.
Correct.
Right? We are not concerned with
Bishu
Sibu Mehto and Arjun Mehto. And this inquiry is connection with Sibu Mehto and also Arjun Mehto. Right? Tell us, so far as Bishu Mehto is concerned, how many charge sheets were issued and who all are the persons involved with Bishu Mehto?
Out of 9 persons, 5 persons, namely Sri Satyendra Prasad, Kapil Prasad, Ganga Prasad and Bihari Prasad and Surendra Prasad were charge sheeted for impersonation and dismissed from their services after holding.
Forget about, they are not impersonator. They are not impersonator. Bishu
They are-
Mehto had, so impersonation is a different charge altogether.
These persons were also given employment against the said lands.
Forget it, they
The
are
details.
impersonator. Forget
Right.
it. Right? That is a separate charge altogether. If a person is impersonating, the charge is different. Isn't it?
Correct.
Their charge is different. Even if the sale deed was valid and a person has impersonated himself to be son of or nephew of or whatever of one or the other person, he is bound to be dismissed. Even if the sale deed is valid. Right?
Right.
Here is a question where it says that the sale deed is invalid on account of the reason that the property did not belong to the vendor.
Right.
Part of the property did not belong to the vendor.
The right
So
to
you
get
do not say
employment-
that the entire sale deed is valid. You say that it is invalid qua certain portion of the land, which did not belong to Bishu Mehta. So far as others are concerned, their allegation is impersonation, rightly dismissed. We don't bother about it. But so far as these two persons are concerned, some of the property of their father has certainly gone to you. Then,
Right.
how do you dismiss it?
On the basis of the total chunk of land,
No,
that
you
was-
can't. You have taken some property and you claim title by virtue of that very sale deed which you say that. You see, in a sale deed, there are 4 plots included, A, B, C, D. And it is found that sale deed which qua A is correct because the vendor had title. But so far as B, C, D is concerned, it is not correct because the vendor did not have the title. So the sale deed would survive at least qua A.
it-
Right? You have not taken any steps. And so far as qua A is concerned, whatever right is flowing to the parties arising out of that particular sale deed has to sustain.
but that has to be a separate transaction.
But you have, that is why he was asking against which property, which portion of the property have you given me employment? Which portion of the property? You have not demarcated. Then, since they are the sons of, since he is the son of the of Bishu Mehto, so whatever be the property of Bishu Mehto, the employment is for that property.
But a particular plots of lands against which employment has been provided to a particular person has not been demarcated. It's a package deal. Like the management and the landowner, they have negotiated that he can provide me at least 6 acres, 5 acres, or any amount of land against which
What is your
negotiations
policy
begin.
against under for how much land you provide one employment?
2 acres.
2 acres. And the land here is only how much? Less than
70
that.
decimals. And the charge sheet reads that during 1980-81, your father Sri Bisu Mahto had falsely claimed to be the owner of the plots of land, which in fact belongs to government of Bihar, Khas land, and had alienated his purported land to BCCL and got your employment done in BCCL as a dependent of land user in an irregular manner, and as such you had necessarily a party to the above fraudulent act.
Heard the learned counsel appealing on behalf of the parties. This petition has been filed challenging the award dated 27/11/2013, passed in reference case number 7 of 1999, by which Central Government Industrial Terminal number 2 Dhanbad, as directed, reads has held that the management of Sudamji area office of Mrs. BCCL was justified in dismissing Durga Charan Mehto from service of the company with effect from 30/11/1994, and the workman has been held entitled to no relief. The learned counsel for the petitioner, while assailing the impugned award, has submitted that the वो दीजिए record लीजिए. The father of the employee, namely Vishnu Mehto, Vishu Mehto, had transferred certain property in favor of the respondent management, while registered sale deed number 773, 774 and 7759 dated 31/1981, 31/1981 and 26/9/1980 respectively. There were total 8 plots and area was 6.95 acres. $6.95. तो 6.95 नहीं है आपके रिपोर्ट में, तो 6.95 एकर्स है. ये रिपोर्ट में
Inquiry report में
6.95
6.95
है ना?
and after what basis this has been held to be 5.85
इंक्वायरी रिपोर्ट में तो 6.95 एकर्स है. The learned counsel submits that on the basis of report of circle officer, the respondent came to a conclusion that some portion of the property so sold did not belong to Vishu Mehto and it was government land, and consequently a disciplinary proceeding was initiated after expiry of 11 years from the date when the concerned workman was given employment under land users scheme. He has submitted that at the stage of inquiry, the petitioner had demanded the copy of the certificate issued by the circle officer Jharia in respect of the purchased property, and also the particular plot numbers, khata number, area purchased by BCCL from his father, against which he was provided employment. But these documents were not provided, and in spite of that, the petitioner was held guilty on the ground that the employment was obtained by misrepresentation, was fraudulently obtained by giving false information about the ownership of the land. The Learned Counsel has submitted that merely on the basis of the report from circle officer, there was no question of coming to a conclusion that the land did not belong to his father. He has also submitted that even as per the impugned order, it has been recorded that as per the report of the circle officer Jharia, out of 5.85 acres of land sold by Bisu to the respondent, 4.58 acres was coming under Gair Abad, and 70 decimal of land under khata number 12 was in respect of which revenue receipts stood recorded in the name of Bhagatu Mehto, within bracket, and others, from which Bishu alleged to have purchased. It was concluded that 5.15 acres did not belong to Bishu, the father of the ex-employee Durga Charan Mehto, and therefore his employment at the initiation of Bishu under the land users scheme was fraudulent and false. The Learned Counsel has submitted that it is certainly not the case of the respondents that the entire land sold by Bishu did not belong to him. He has also submitted that the registered deed on the basis of which the respondent has taken possession and executed by Bishu Mehto were never cancelled. He has submitted that the right title with respect to properties could have been decided only through title suit and on the basis of report of circle officer, no such conclusion could have been drawn that the property did not belong to Vishu Mehta. That is your case? The learned counsel appearing on behalf of the respondents while opposing the prayer has referred to the records received from the concerned court and has submitted that the discussion with respect to the two Durga Charan Mehto and Kedar Mehto is in page number 171, which is a part of the inquiry report. He has submitted that as per the inquiry report, total 6.95 acres of land was sold by Visu Mehto to the respondent by way of registered sale deed dated 3181, 3181 and 26/9/1980, and they did not produce the sale deeds by virtue of which Vishu Mehto had purchased the property, and there was no entry in the name of Vishu Mehto in the revenue records, and his name was not entered as tenant in the record. He has submitted that on the basis of the inquiry report, there was no doubt that the property never belonged to Visu Mehto, and he had sold the property fraudulently to the respondent company, and therefore the employment given to Durga Charan Mehto on the basis of under land losers scheme was a fraudulent employment, and accordingly the award passed by the learned court does not call for any interference. नेचुरल जस्टिस में क्या बोलना है आपको?
Ladyship, as also the tribunal has referred to a judgment that unless the petitioner shows that prejudice has been caused by non-supply of documents, non-supply of documents would not vitiate the departmental proceedings.
The learned counsel for the respondent has submitted that so far as violation of principles of natural justice and in as much as certain documents having not been supplied is concerned, the same may not have any bearing in this case in view of the fact that the ex-employee Durga Charan Mehto was never prejudiced by non-supply of one or the other document, and on the basis of the report of the circle officer, it was clear that the property never belonged.
Ladyship, there was a preponderance of
Vishnu.
probability.
Sorry?
There was a preponderance of probability.
The learned counsel has also submitted that the case has been decided on the basis of the principles of preponderance of probability. The petitioner, having not submitted the connected title deeds before the inquiry officer, had no claim over the employment which was granted to the petitioner under land users scheme. He has relied upon the judgment passed by the Honorable Supreme Court in the case reported in.
Ladyship, I will supply this, ladyship.
They did a citation. to submit that unless the prejudice is shown to have been caused, the violation of principles of natural justice has no role to play in the matter of disciplinary proceedings.
Second paragraph. It is required to be noted that as such there is no finding that non-supply of some documents has resulted into any prejudice caused to the delinquent employee. Mere non-supply of the documents which may not have resulted any prejudice caused to the employee, the order passed by the disciplinary authority cannot be satisfied.
The learned counsel has relied upon the judgment passed by the Honorable Supreme Court in Civil Appeal number 7257 of 2022 within bracket State of Punjab versus Nakshatar Singh, dead through legal representative, and has referred to and has held that it has and has submitted that it has been held that mere non-supply of the documents which may not have resulted in any prejudice to the employee, the order passed by the disciplinary authority cannot be satisfied. In response, the counsel for the petitioner has submitted that the petitioner was never served with the inquiry report.
But in regard to inquiry report, that case is some
Yes.
documents.
The learned counsel for the petitioner has submitted that non-supply of documents has caused great prejudice to the petitioner, and therefore said judgment does not apply to the facts and circumstances of this case. He has also submitted that even as per the impugned order, only 5.15 acres out of 5.85 acres did not belong to Vishu Mehto. Certainly, and so far as 0.70 decimal is concerned, it is not in dispute that the sale belongs to Vishu Mehto. Correct? As per the impugned order, which he had purchased from one Bhagatu Mehto and others. Arguments concluded. Judgment का date which is January में 15 के बाद वाले बीच का 15 के बाद वाला जो डेट्स है ना उसके अनुसार देंगे डेट। हर हफ्ता में 2 जजमेंट केस करते हैं। लेट मी सी व्हाट कैन बी डन। थोड़ा ज़्यादा ही करते हैं। कुछ तो उनका था ना।
कुछ
वो जो 2 आपका इंक्वायरी रिपोर्ट में 2 जन थे, दूसरे का क्या हुआ? He did not challenge.
I am not aware.
Appearance memo दे दीजिए सर। 15 को एक रखें। हाँ, इसके बाद 15 के बाद रखें। 21 जनवरी, ठीक, 21 जनवरी। The petitioner has already attained the age of superannuation. कोई आइडिया है? 94 का डिसमिसल ऑर्डर है। What is his age?
No, I couldn't hear. Age of the petitioner. No, I am not in a contact with these persons.
Okay.
So I cannot give the.
That's
रिटायर कर रही है आपको पता नहीं है जो भी
Item 5 WPL 5620 of 2021 along with item 6 and 7.
Yes, petitioner. Who is appearing? आप appear हो?
I am for the respondent basis.
Which matter do you argue first?
5620.
Argue.
So on the last occasion, it was only on one issue, my lord, that if the dispute exists, my lord, that has to be referred to the board or the court.
Which judgment are you referring?
We are referring to the judgment of para 21 of the judgment.
Let us see the facts of the case. Read facts. Kindly read. Read the facts.
Yes, ma'am. Page number 6, my lord.
Page number 2. Page number 2, read it.
Of the petition, ma'am.
Yes.
What-
नहीं, of the judgment. Judgment पढ़िए, judgment. Judgment cite करेंगे तो facts के साथ cite करेंगे. नहीं है? Two copy. उनको दे दिया क्या? भाई इनको दीजिए पढ़ने के लिए.
Lord, it is the case of one such Kuldeep Singh, the appellant workman, that on 8/10/1990 he was appointed as the data entry operator on daily wages and he worked as such till 28/11/1991 and thereafter on ad hoc basis and worked up to 26/5/1992 without any break. When his services were terminated by the Instrument Design Development and Facility Center, the respondent management herein, according to him, no notice or compensation in lieu thereof was given for terminating his services, though he had worked for 240 days in the preceding 12 months. According to the appellant, workers junior to him were retained and even fresh appointments were made after the termination of his services, which is in violation of provision of Section 25L to H of the Industrial Dispute Act 1947. It is the case of the respondent management that the appellant workman was working on daily wages to meet the exigencies of work and his contract of employment was on day-to-day basis and that the workman did not render duty for requisite number of days in the 12 preceding months as claimed. It was further denied that any worker junior to the appellant was retained in service or any fresh appointment was made. On 12/12/2003, the Labour Court, after adverting to the reference made by the Governor of Haryana as to the unemployment of appellant and after framing necessary issues, has held that the respondent management is an industry within the meaning of Section 2J of the Act and found that the workman rendered the duty for more than 240 days in the 12 preceding years, but the management terminated his services
Please
without.
pause for a moment. Here is a case where the reference was made
Yes, ma'am.
and the reference was answered. The issue before the court was whether the claim was stayed. And here is your case whether the reference has been denied. There is a vast difference between
My
the
lord,
two. Once the reference has been made, the court has no option but to answer the reference. The court will not go into the staleness of reference because there is no limitation and no time period prescribed for referring the matter to dispute.
yes, ma'am.
But the authority have got a right to exercise their jurisdiction and power, though it is administrative, whether the dispute has to be at all referred for arbitration.
Yes, ma'am.
So how does this judgment, this fact
Lord,
of this judgment is
yes,
going
my
to
lord.
help you?
The observation made by the Honorable Supreme Court, my lord, says that only thing has to be seen that is there any dispute exists or not. In my present case, my lord, the dispute is existing, my lord, and the impugned order which the respondents have passed, my lord, they are themselves admitting, my lord, that there is a dispute, but they are saying that subject not for consideration. My lord. They are admitting that there is a dispute, my lord. The only thing they are required to just refer the matter, my lord.
Read para 14, internal page 11.
we have already noted that the Labour Court held that the appellant has completed 240 days in 12 preceding months, and the respondent's management terminated the services without complying with the provisions of 25 of the Act. And the order of the termination dated 26/5/1992 is illegal, null and void, and deserves to be set aside, but only on the ground of delay rejected his claim in
So,
its
and
entirety.
Labour Court decided it in two parts. On merits, it said that
Yes.
the procedure was not followed, but on account of delay, it said that no relief can be granted.
Yes, ma'am. On the account of delay, my lord, in the entirety, they are saying that cannot be granted. That the same thing, my lord, I am submitting, my lord. They are only required to refer, my lord. They do not have the jurisdiction to decide by their own. And since, my lord, on the ground of delay in this judgment, my lord, they are saying that it is not, it has been rejected on the ground of delay, my lord, in the entirety. Same, my lord, they are also saying that 16 years or 18 years is, my lord, the delay in this present case. I am saying that at any time, my lord, it can be referred. Para 21 of this judgment is saying, my lord, that only thing has to be seen that if there is any dispute existing or not. The authority which is required to adjudicate the matter is the court or the board, my lord, not the appropriate government. But by themselves, without any jurisdiction, my lord, they have adjudicated the matter. And in the impugned order also, they are saying that the dispute is existing. So they are admitting that the dispute is existing, my lord, and they are not referring the matter. I am only on this single issue.
We just see para 19.
Merit.
Yes.
We have already pointed out that there is no limitation prescribed in the Act, nor in any other local act prescribing such period. We have also referred to the materials placed by the workman by referring various representations from the day when his services were terminated until his last representation dated so and so. To the manager, Jharkhand, Chandigarh, the workman has proved that he was agitating his termination one way or other with the authorities concerned. The particulars furnished clearly shows that the appellant workman was fighting for his cause before the management as well as with the state government, including the chief secretary and the minister of concerned department. Ultimately, the state government has made reference on such and such to the Labour Court for adjudication. Authority has sent to the Labour Court for adjudication. Subsequent para 20 and 21. Lordship, Section 10 of the Act also says, my lord, the same regarding the reference. Whatever be the dispute, my lord, that has to be seen by the court or the
So
court.
the authority has to act as a post office.
My lord, they are only required to refer the matter. For that, they are, my lord,
Anytime.
it is written, my lord, at any time.
Here you were
Section 10.
terminated on 14/2/1998, right?
Yes.
You apologized on 30/8/2001. You raised a dispute by letter dated 5/4/2016.
Yes.
And there is complete gap from 2001 till 2016. Absolute silence, correct? यही है ना?
Yes.
और
But
दूसरा
my-
केस बताइए.
In this case, my lord, the issue is, all the issues are same, my lord. Also, one point in the third case, my lord, regarding compassionate amount.
So third is 5641, 47.
47.
इसमें लिखिए WPL number 5620 of 2001. The learned counsel for the petitioner has submitted that by the impugned order the government has refused to refer the dispute for adjudication. They have submitted that there is no time period prescribed for reference, and therefore the authority had no other option but to refer the dispute for adjudication in terms of section 10 of the Industrial Disputes Act.
Also, my lord, the law
He
of
has referred
limitation
to the judgment passed by the Honorable Supreme Court in the case of Kuldeep Singh versus GM Instrument Design Development and Facilities Center, decided on 3rd of December 2010. To submit that, in the said judgment also, it has been held that there is no prescribed time limit for appropriate government to exercise its power under Section 10, and if any individual dispute exists or is apprehended, the appropriate government at any time can refer the dispute for inquiry. That's all. In this case, the termination of service is dated 14/2/1998. The petitioner apologized by filing representation on 30/8/2001 and raised the dispute against his dismissal on 5/4/2016. During the course of argument, no explanation has been furnished by the petitioner for not raising the dispute for during the period from 14/2/1998 to 5/4/2016.
since law of limitation is not applicable on
Yes,
industrial
he
dispute.
says that the learned counsel submits that there is the law of limitation has no application so
May I
far
point out
as
only one?
reference of dispute is concerned. आपको कुछ
May
बोलना
I
है?
point out only one thing? It was not the Ajnath Mahto who raised the matter before the reference. He had not gone. It is the Jharkhand Colliery Shramik Union raised the issue 5/4/2016. My lord, not the person who was dismissed. वो कभी नहीं
वही
आया.
होता, वैसे ही होता है. पर्सन जाता है यूनियन के पास और वो डिस्प्यूट फेस करता है. आपको कुछ बोलना है?
I have stated that I have questioned the locus standi of Mr. Vijay Kumar who has filed this instant petition.
The learned counsel for the respondent has submitted that Vijay Kumar has filed the present case in his individual capacity
He has no locus.
and the union has not filed the same. The
He is a member of the unregistered.
and he is simply a member of the union.
He just a member.
It goes to show that union as such
Lordship,
is not aggrieved.
to this contention, my lord, I may be permitted to reply, my lord. Section 36 of the Industrial Dispute Act, my lord, says that if an executive member, my lord, authorized by the union, he can represent the matter before the court. Vijay Kumar, my lord, is the executive member, my lord. Certificate to that effect has also been annexed
Not by the union.
by the union.
No, it is by the vice president
The
who
person-
doesn't have the
union
authority.
is, my lord,
How can
is
you
not
say
a
that?
person who will authorize, my lord. He will certainly authorize a person to give authorization to the executive member.
Where is that
We have
resolution?
annexed
That,
in our agenda, my lord.
where is that resolution that the union has authorized Mr.
Yeah.
Rahul Kumar, working president, to give this certificate?
So far as my lord Vijay Kumar is concerned, my lord, the certificate is annexed in the rejoinder, my lord. And now the section
Certificate issued
36.
by working president, not by the union. Neither by the secretary, not by the president. No resolution of the union that Mr. Rahul Kumar will represent and give such authorization. It is by one Mr. Rahul Kumar who has given himself the power.
The learned counsel for the petition in response has submitted that a
It is-
certificate dated 24/9/2024 has been annexed along with the rejoinder to show that Vijay Kumar was the authorized person to represent Jharkhand Colliery Shramik Union since 2014. Yeah?
Yes, ma'am. As per 36 of the act.
And the said certification is as per section 36 of the
Industrial.
इंडस्ट्रियल डिस्प्यूट्स एक्ट. ये हो गया. उसके बाद कौन सा 5647 with respect to WPL number 5647 of 2021, the learned counsel has submitted that the date of termination is 24/11/2007, and in the meantime, a circular dated 3/1/2011 was issued, whereby ex-employees who were dismissed on charge of absenteeism could be taken back in service by way of fresh appointment. On 5/2/2012, the petitioner filed a representation seeking apology. An industrial dispute was raised on 21/7/2015, challenging the order of termination. Correct?
Yes.
He has submitted that all other arguments in connection with WPL number 5620 of 2021 will also apply in the present case. आपका भी same argument है? इनका लिख दीजिएगा that they have submitted that the impugned order does not call for any interference. इसका so far as WPL number 5632 of 21 is concerned, the death of the ex-employee is dated 6/7/2002. The petitioner raised a dispute claiming compassionate appointment on 19/6/2016, and by the impugned order, the authority has refused to refer the dispute for adjudication. बाकी सब argument same है? Arguments concluded. Goes for judgment on next Tuesday. Tuesday को judgment क्या आएगा? 10 तारीख? 2 तारीख?